arrests for DUI in Fort Lauderdale. In the eyes of the law, things that occur prior to the time of arrest and things that happen after carry varying weight. Therefore, it is important to understand the point in which an arrest actually occurs. When is a person considered under arrest? Is it when they are handcuffed? Put into a squad car? When they are fingerprinted and booked at the station? The moment of arrest actually occurs in the instant in which the police officer utters the phrase, "You are under arrest for." At this moment, the law enforcement official is asserting his legal authority in taking a person into custody and charging him or her with a crime. Up until that moment, even if a person is being detained or questioned by a police officer, he or she is still considered at liberty. If an individual is pulled over while driving by a police officer for any routine traffic offense, and that officer perceives that there is probable cause to suspect that the individual has been drinking, say there are empty beer cans in the floorboard of the car, then they may have the person step out of the vehicle. They may handcuff the individual, or have them sit in the squad car while they search the vehicle, but the individual is still not under arrest. The police officer will then ask the individual to submit to a field sobriety test and/or a breath analysis test. Once the tests have been administered, the police officer will decide whether or not to arrest you for driving under the influence. However, if you refuse to take these tests, you can still be arrested for driving under the influence. In fact, you will face even more serious charges if you refuse to comply under the implied consent laws of your state. Probable cause that an individual has committed or has been involved in the commission of a crime is enough legal ground for a police officer to arrest that individual. This is why you can be arrested for driving under the influence even if you refuse to take a field sobriety test or chemical test. If the police officer has probable cause based on observational evidence that you have been drinking, then that is sufficient. Since a police officer can arrest you whether or not you submit to a test or not, and since the punishments under the implied consent laws are so steep, it is never in a person's best interest to attempt to avoid arrest by refusing to comply with an officer. Nevertheless, this does not mean that a person should be so compliant as to offer up more information than necessary to the police officer. If the police officer fails to read the person the Miranda warning, then this divulged information won't be admissible as evidence in court. However, most police officers take special care to read this warning. Anything that you say after having this warning will be viewed as a waiver of your Fifth Amendment rights and can be used against you in court. When experience counts, call Robert Malove. Get help now. Call 954